The legal responsibility of a landowner or a person in possession is that they have to safeguard the premises to ensure that there is not a dangerous condition existing on the premises that could give rise to an accident that could then cause an injury. So the classic case is a pothole, right? If there's a pothole there and it's dark at night and somebody steps into it and they fracture their ankle, the landowner or person in possession would be legally responsible for that. The kind of injuries that we see with slip and fall accidents vary. It could be a fracture, it could be the kind that you can't see. Maybe they tore the meniscus in their knee, or maybe they tore the rotator cuff in their shoulder. They may sustain a bad laceration that could result in significant disfigurement. As far as our slip and fall clients are concerned, we are very much aware of the fact that judges and potentially jurors and insurance representatives may have a lot of doubts about the claims that our clients are making. But we prove our case through the medical documentation of the matter. We prove our case through the liability aspect of the case. So if there were surveillance cameras that caught the accident, we make sure that we get that right away. If there were witnesses who were there, we make sure that we track them down early and get statements from them. One of the very important things that must be done in a personal injury case is to act fast. So let me give an example. You could have a slip and fall or a trip and fall. It could be an intersectional collision with two cars. Get the surveillance footage. Get it quickly. Not everyone keeps it as long as others. Some may only keep it for 24 hours, 48 hours. Others could be 72 hours. In the case of like Macy's, the department store, they keep it for 30 days. But you've got to get that footage because footage doesn't lie. The goal of the insurance companies, as it relates to our accident cases, is to minimize the amount of money that they have to pay out. Whereas in our case, our interest for our clients is to ensure that we achieve full and fair monetary compensation for their injuries. If you borrowed $1,000 from me with the promise you'd pay me back in a week, and after 1 week you said, I don't have the money, but I'll give you $500 in full and fair compensation, I'd say no. You owe me $1,000, pay me the $1,000. But insurance companies don't want to give you 100 cents on the dollar. You deserve it, and you should get it. That's why you pay the insurance premium you did. The types of damages that are available to our clients consist of compensation for your lost wages, compensation for your medical bills, and we all know how much that can be. You go into a hospital, even if it's just an emergency room visit, and you come out owing $10,000. So the medical expenses can really be big. The other type of damages would be loss of enjoyment of life. The things that you used to do that you found joyful that you can't do anymore. And then also, it's the pain and suffering that you had to experience for all of that time. Those are the types of damages that are available to our clients. The experience that I have with premises cases, and by that I mean a slip and fall case or a trip and fall cases upon the premises of another, is that I've been doing it for 35 years. I know what the law requires. We must first prove that there was a dangerous condition. Was that ice on a step? Was that a banana peel on the floor? Was it a spill? Was it a pothole, a crack in the sidewalk? We know we have to prove a dangerous condition, which is usually very easy, but we also have to prove notice. We have to prove that the person in possession, the landlord, the owner of the property, either knew about that dangerous condition or should have known about it, such they should have taken corrective measures to rectify it. Clients hire my firm for a variety of reasons. The first one I would say is goodwill, and by that I mean we have represented so many people over the 35 years that I have been practicing, and those past clients reach out to people that they know who were injured, whether it be their neighbor, their coworker, a family member, and they recommend those people to us. That's one way. The other way is with our website. We have a lot of 5-star reviews. And whenever anybody reviews my website and they see those reviews, they realize that this is a really good firm, and that we are. I would say that our current clients and past clients would say of our firm is that we are very expert in terms of what we do. You know, there are those who are a jack of all trades but a master of none. We focus in on the personal injury world, and as a result, we're very knowledgeable in that area. But we also care about our clients, and that really shines through. Our firm strongly believes that communication with our clients is paramount. If a client calls our firm, we have a strict rule. You must get back to that client that day. Do not leave at the end of the day until such time as you do. And speak to that client about whatever concern or problem that they have. And then, if necessary, speak with others in the firm, whether it be with me or any of the other lawyers that work for the firm, to find out the best way to resolve the problem or the concern or the question that the client has. The law office of Thomas Lavin is a medium-sized firm. We have about 25 staff members. There are 3 lawyers that work for me. And the good thing about that is we are a close-knit group. It's almost like a family environment. I have a lawyer who's been working with me for over 25 years. And the fact that we are so close as a group really shines through, and the clients feel that. And it's special. It gives them a warm feeling about what it is we are doing for them. What our clients can expect after the initial consultation with our office as it relates to premises cases, whether it be a slip and fall or a trip and fall case, is that you are going to be apprised of the good, the bad, and the ugly of your case, because every case is different. The facts may be such that we don't know if we're going to be able to prove that the owner knew about ice on the step. It may be that there may not be insurance coverage. We don't know that. And we are going to tell you that at the initial consultation so that you will know what the possibilities are of your case.